as a starting point, one of the areas that we want to look at is if you have a fair bit of understanding of AI rather and intellectual property. So from your basic understanding of artificial intelligence and intellectual property, is it right, or do you think that AI systems and AI should be granted intellectual property? Because that has been the biggest discussion to date. Why should we allocate intellectual property to AI systems? And there have been court decisions. People have gone before the Senate in America, just trying to plead with them to ask them that, can you allow us to register intellectual property for systems? And one of the key forms of intellectual property that has been affected is copyright. And how is copyright intersecting with artificial intelligence? Because as we said when we began, is the issue of prompt engineering, where you write up some text on your chatbot, whether that's ChatGPT, and then it gives you this response. So the response is obviously going to be based on the prompt that you've given it. So those are some of the issues or some of the areas that are very, very integral. So how does the originator of this copyright, or how does the owner of this copyright protect themselves from a person such as yourself, who is then taking this text or this content and feeding it onto the chatbot? Because what that happens is that it is then also being used to train the various models. And I don't know if at this point, maybe Perpetua, you have anything to add on to how copyright and AI intersect, and what are the issues that can then come up from the continued use of AI in respect to copyright?
I've had the privilege of practicing IP for 10 years now. And it's always been, we've always defined intellectual property as the creation of the human mind. And then here comes artificial intelligence, where there's no consensus on what exactly is artificial intelligence. But for the purposes of this conversation, artificial intelligence is basically computer systems that are able to perform tasks that were historically done by humans, predominantly by humans. And these tasks include making decisions, solving problems, creating. I think Wilson has mentioned that. And we now have artificial intelligence, and it is innovating. And so from just the definition, already you can tell we've entered into a complex area, because we can make two distinctions from the definition. One, it appears that we have inventions or we have works that are being created by human beings. We've not stopped innovating, but we are faced with the new reality where we have AI that is actually innovating. And our laws speak of the human person as an inventor. The laws that relate to copyright speak of an author as a person. And here we have a machine that's generating work, what is called generative AI. And so that begs the question, who will be the owner of work generated by artificial intelligence? Because clearly they do not fit within the definition of our laws as they are currently. Interestingly, yesterday there was a filmmaker, and he really intrigued me. His work really intrigued me, because he mentioned that for him it's important that his human creativity is expressed in his work. He actually uses artificial intelligence to enhance his work. So for starters, he uses artificial intelligence to create his work. Secondly, he protects his work using copyright. And thirdly, he uses licensing arrangements to commercialize his work. So I'm quite curious. I think I would like to interrogate him just to find out, so to what extent does he disclose that the aspects that were generated by artificial intelligence and the aspects that he applied his human creativity? Wilson, just allow me to mention is that we are indeed discussing a very complex issue, because when you're talking about the interplay of AI and IP, you can see where the complexity arises. So maybe our participants can keep that in mind as we move along in these discussions.
Thanks, Perpetua. And I think maybe just to also hammer home the point of human ingenuity or of human origination, because when you're talking about intellectual property, which is copyright and trademark, a good number of countries insist, at least for the intellectual property laws, whether that's copyright or whether that's patents, a good number of laws insist that there should always be a human element in the creation of works that are subject to intellectual property, so that If you are then coming up with content, or if it's an AI that's coming up with content autonomously, that's to mean by itself, then that is not attributable it's not subject to be granted intellectual property. So whether it's in America, where the courts have decided that, we understand that, the space that is artificial intelligence is growing at a very, very rapid pace. And perhaps there might come a time when the laws need to change just to accommodate artificial intelligence. But as at now, and where we are currently with the existing levels of technology and with the existing level of artificial intelligence, granting artificial intelligence intellectual property is something that seems to be so much out of the question that registries are not even willing to consider it. But I think even on a broader scale, one of the biggest issues that we are facing, not just as a country, but perhaps as a continent, is the fact that the level of understanding of artificial intelligence is still somewhat lagging behind. And that is demonstrated by the fact that there is little to no regulation of artificial intelligence on the continent. So that if you do not understand what artificial intelligence entails, if you do not have laws, policies, rules, regulations guiding artificial intelligence, then even talking about attribution of intellectual property to artificial intelligence then becomes a challenge. So I think even as we're looking at intellectual property and the interplay between that and artificial intelligence, there needs to be a sort of regulatory mechanism or a sort of understanding or comprehension of what artificial intelligence entails before we can then move towards attribution of intellectual property to AI. But away from that, when you look at AI inventions, they can basically be grouped as into three main categories. So the first one is what we call the AI-assisted inventions. So the AI-assisted inventions are made using AI as a tool in the inventive process. So this could be, an example could be how AI is used to discover drugs and select particular candidates to be tested for that particular drug. The second form of artificial intelligence invention would be the AI-based invention, so that you can create a hardware and then the sort of supplementary software is primarily based on artificial intelligence. So a good example would be a translator, a language translator, so that if you develop hardware, speak to it in a foreign language, then it can translate this, it can translate the language. And the third one would be the AI-generated inventor. So that's your typical ChatGPT, your Gemini, your Microsoft Copilot. So in looking at all these things, you then get the understanding of the fact that, when it comes to artificial intelligence and intellectual property, copyright, although it forms a huge chunk of the debate when it comes to intellectual property, it's not just the only one. And so what level of human intervention goes into developing these systems, so that if you were to grant you intellectual property, then you can show that there's some level of human ingenuity or some human origination in the creation of or whatever AI system or whatever the AI system has come up with. So in a nutshell, even when it comes to patents, not just for copyright, but even when it comes to patents, you still have to show what level of human intervention has gone into developing or designing the invention that the artificial intelligence system has designed. Perpetua, I don't know if there is anything you need to add when it comes to artificial intelligence and patents more specifically.
What for me is the most challenging type of AI invention is what is referred to AI-assisted inventions, which is what you've also talked about, where we have an inventor who uses an AI platform or an AI model, depending on what name you want to give it, and they come up with an invention. So you can see that the inventor actually made the decision on what was the outcome, what was the AI outcome. Allow me to just try and explain why this is quite challenging when we are looking at the IP considerations. Under most laws that provide for patent protection, and let's just start from the TRIPS agreement, because I think most African countries are members of the TRIPS agreement. So we have three main requirements if you want to protect a patent. One, your invention has to be what we call it novelty. The requirement is novelty, or new. It has to be new, meaning that it does not exist anywhere in the world. And then the second requirement is what we call inventive step or non-obviousness. And the third requirement is industrial applicability. It means that your invention can be used in industry. So let's come to the second requirement, inventive step. Those who are familiar with patent laws, there is the hypothetical man when we are talking about inventiveness, which is a person having ordinary skills in the art. So when you're testing whether an invention is inventive, we consider a person having ordinary skills in the art and see whether that invention was obvious to them. And if it satisfies that requirement, then an IP office will grant you patent protection. But here comes artificial intelligence. It's certainly not a person having ordinary skills in the art, because these machines can solve complex problems. They are coming up with very mind-blowing inventions. So I've seen some jurisdictions are moving from POSITA to POSITA, where the T stands for either a team or a tool of innovation, including artificial intelligence. So it would seem that jurisdictions, and especially on the African continent, have to adapt their laws to make provision for when artificial intelligence is the standard that is being used, or rather it is the manner in which you have solved a complex problem. So, I mean, you can see where the challenge is coming in. So if I invent and the test is a person having ordinary skill, but here we have an AI system that is above a person having ordinary skills. So we really need to rethink our laws as far as that is concerned. And when we are looking at the requirements for inventiveness.
Thanks, Perpetua. And I think you are doing a fantastic job at just painting the complexity, which is the actual reality of the topic of artificial intelligence vis-a-vis intellectual property. And I think one of the things that you sort of touched on is the aspect of disclosure, because when you're going to file for a patent, it's a give and take. So what you give is that you disclose all the information. So you have to disclose how you've come up with this invention, what is the step-by-step process, how can you apply it industrially. And so that is the give. And what you take in return is protection over that particular invention, so that it allows you to sort of have monopoly, for lack of a better word, and people need to sort of have your permission before they can reproduce it, or you're the only one with the exclusive rights to create that particular product. But one of the things that I have seen being discussed in avenues of artificial intelligence and intellectual property with regards to more specifically patents is, patent applications rely heavily on the concept of disclosure, because, when you're going to file an application, you have to disclose. You have to tell people that, this is how I came up with this particular invention. These are the methods that I used. This is what we did to sort of come up with the holistic idea. So if the creators are not willing to disclose fully, because it's very, very possible for an individual to go to a patent office and say that I came up with this thing all by myself without any artificial intelligence intervention. And if the examiners are not keen enough, they might just end up granting that particular patent, whilst overlooking the fact that this thing was actually developed either partially or wholly by an artificial intelligence. So that is also a consideration that patent offices and intellectual property rights has to consider when it comes to the development of or to the granting of intellectual property to inventions that are presented by inventors. And then the concept of separate registries. I think once upon a time we had this discussion where is it time to consider, because the capabilities of a machine or of an artificial intelligence are very, very different from that of a human being. As you said, Perpetua, this thing can solve complex equations in a sort of a split second or whatever period of time, which is definitely shorter than a human being can. So that means that how quickly it can come up with new inventions, it can come up with new innovations, is very, very quick. So maybe one of the things that people should sort of consider looking into the concept of separate registries, so that when if you are having, it's a competition of equals, so that if you have your AI assisted or a purely AI inventions, then you can classify, you can categorize you in one class. And if you are going to remain with the old school way of looking at intellectual property as being solely attributable to human inventions, then we can sort of have that so that we separate the two registries, and so that people are not competing where they are unable to compete.